Good afternoon and good morning to everybody. Welcome to you all for attending today's webinar on EB-5. Hope you're all having a great week. Today, my colleagues and I will be doing an overview of the EB-5 process. I will start with a brief introduction of the EB-5 visa. So the EB-5, that's the common name for the visa, or the Immigrant Investor Program, was established by the US Congress through its Immigration Act of 1990 to stimulate the US economy by allowing foreign entrepreneurs to live and work permanently in the US after the EB-5 investment into a US commercial enterprise. So this investment allows foreign investors to apply for a green card or permanent resident status by investing into a new commercial enterprise or a regional center for the investor and their dependents, that is, the spouse and unmarried children under the age of 21. Commercial enterprise is for any for-profit activity formed to conduct a lawful business, including but not limited to sole partnerships, joint ventures, corporations, business trusts, or any other entity which may be publicly or privately owned. Through the years, several reforms were made on the EB-5 program, including the creation of the Investor and Regional Center Unit, which oversees all the auditing, form design, regulation development, and policy creation. In July 2019, USCIS published a final rule of EB-5, which took effect on November 21st, 2019, increasing the investment amounts to $900,000 from $500,000 in a targeted employment area. We will go over what the TEA and its requirements are later in the presentation, and increased it from 1 million to 1.8 million in any other area. Another significant change made is that USCIS will now designate the TEA instead of the individual states that used to designate it before. Also, most recently, on July 24th, 2020, USCIS announced that it was changing its policy for EB-5 capital redeployment. These, along with other updates, will be discussed more in detail in this webinar. So what are the general requirements for an EB-5 investment? The investment has to be at risk and placed into a new commercial enterprise. So as I said before, it's $900,000 if it's in a TEA zone, otherwise 1.8 million. We have to show that the investment is derived from lawfully derived sources. So the source of funds has to be decided and looked into. One of the most important requirements is job creation. There is a requirement of a minimum of 10 new full-time permanent jobs when you invest into an NCE, which is a new commercial enterprise. Or if it's a previously existing business, it can be 40% increase from the pre-investment levels. And also there are other nuances that, like if the investment is in a troubled business area, you can preserve the jobs or do a combination of creating jobs and preserving it. So one of the requirements for a direct investment is also that the investor will engage in day-to-day business or formulation, depending on the type of investment. So here is a very simple chart showing the EB-5 process. As you can imagine, there are many requirements and nuances that we will try to cover briefly today. So once we decide on the kind of investment to create the new commercial enterprise, if the investment is in a regional center, one can invest in an existing regional center, create your own regional center, or rent a regional center, which is like a hybrid model. Or the investment can be in a direct investment into an NCE, which is a new commercial enterprise. Verification of source of funds is a very important step that the attorneys normally do to ensure that they are from lawfully derived sources. Preparation of business plan is an important step if it is a direct investment, or you can utilize the already approved one if it is investment through the regional center. Then once we have all this ready, we would file the form I-526 along with all the supporting documentation. This application, it's important to remember that this application in itself does not give the applicant a valid status in the US until the application is approved. The current processing times for an I-526 are 24 to 47 months, and in some cases, it has taken longer. So once approved, once the 526 is approved, a conditional green card can be obtained either by consular processing if you're outside the US, or an adjustment of status if you're already in the US in a valid status. Once this step is done, the next step is to file for removal of conditions, where you get a conditional green card for 2 years. This is done by filing a form I-829 with the required proofs of complying with the conditions required for the EB-5 within 3 months prior to the end date. Once you receive a receipt for extending the CR status, it's for 18 months, it's pending adjudication. At the end of that is when you'll receive your permanent green card, and it takes anywhere from 18 to 36 months or even longer in some cases. So that was just a brief overview of what the process is for the EB-5 application. And now to discuss the investment for EB-5 through a regional center, please welcome my colleague, Naya Patel from the New Jersey office.
Hello everyone, I hope everyone is doing great. Good morning and good afternoon. I'll be discussing EB-5 investing through regional center. Regional center is typically a business enterprise that has filed a detailed business plan and other documents demonstrating its ability to create at least 10 qualifying jobs for each potential foreign investor it may take on. USCIS has already approved the general plan and job creation methodology, business structure, providing investor required policy making, roles, etc., and overall metrics. Regional Center provides all business and project related documents, information, and investor typically utilizes the Regional Center package and adds his or her own source of funds of documents, the Form 526 and other biographic related documents. The general process of the regional center. So first, the investor should have to conduct a due diligence using a qualified financial analyst and the immigration attorney. The immigration attorney only typically considers the immigration aspect of regional center and underlying project, but not the financial matters. Immigration attorney will work with investor to identify source of funds and documents at the same time to properly meet the stringent source of funds evidence requirements. After the Form 526 is filed and green card is approved, Regional Center will provide all those documents to investors to demonstrate the fulfillment of business plan objectives and create the requisite jobs, investment sustenance, remaining at risk, and although for the investors to file the 529 petition to remove conditions. This is the flowchart for Regional Center. So as discussed, and regional center, represents in one of the two ways for EB-5 investor to obtain conditional permanent residence. The other being the direct investment will be discussed by Hafiz, that is directly investing into the new commercial enterprise. So what this chart is about is, it shows that the investors directly investing directly into the project is what regional center does is sets up an investment fund of the for the benefit of the EB-5 investors. Investor purchases the equity stakes in the investment fund, and then the funds either purchases equity in the job creating entity, that is the equity model, or lends or loans the job creating entity money, that is called the loan model. And that the job creating entity then uses that same investment from the fund in the project to create the jobs indirectly. So the difference between regional center and the direct investment into NCE is, so the regional center is the foreign investor invest into the NCE, which is managed and operated by regional center, which is in turn has been pre-approved by USCIS to take on the foreign investors through which the investor would be eligible for permanent residency. Regional center here utilizes the funds in accordance with the pre-approved business plan. It also the regional center has also filed the documents to demonstrate its ability to create the required jobs participating into investor and otherwise meet the other EB-5 requirements. Regional center here utilizes induced and indirect job creation. That is, economic projections will determine how many jobs can be credited to a particular project, and thus how many investors at the regional center can potentially be taken on it and the project of EB-5 purposes. Regional center here investments typically is completed at one time. Regional center typically requires payment of admin fee, that is generally 40K or 60K plus, in addition to EB-5 investment. Regional center has prepared and obtained general approval of a business plan. The main difference between direct investment and regional investment is the job creation. Regional center can use induced and indirect jobs based on economic projection. Meanwhile, the direct investment that is invested into NCE must do the hiring at the same time. Next, next slide will be discussed by Hafiz, and he will go to more detail into direct investment. Over to you, Hafiz.
Thank you, Naya. So direct investment tends to be a bit more complicated. In a direct investment, the investor injects funds directly into the NCE, the new commercial enterprise, and they're usually taking an equity position. Which entity will ultimately use the funds to create the jobs, direct hiring, basically, W-2 qualifying employees. EB-5 direct investment essentially means the foreign investor has directly established or acquired an ownership interest in an NCE, which they will directly operate or develop. An example would be an investor partnering with someone to open a new restaurant or a hotel or something else where they take either in an LLC, it would be a membership stake, in a C Corp, it would be share ownership. Whatever the case is, ultimately the investor looking for EB-5 benefits has to have some participatory role in policy formulation or management. That's mandatory. Some people believe that it's passive. Even a regional center, it's not passive. It's actually, there is a statutory involvement requirement for policy formulation, and it's done through through various mechanisms. In a direct investment, the documents need to be very carefully reviewed and prepared such that participation is there. All right, so similar to the regional center, in a direct case, 10 new hires must be, 10 new permanent employees, full-time employees must be hired by the NCE. Here, we have to do direct hiring, not indirect or any type of induced job creation, which is permitted in a regional center. What that means basically is that that entity that the investor, the EB-5 investor has invested in must be the job creator. It is possible that there's a subsequent entity that is wholly owned by the primary investment entity, but ultimately the ownership has to be wholly owned. Otherwise, you will not qualify for the jobs created. In terms of new hires, it's all about the position. It doesn't necessarily have to be the same person. It could be, you know, John today, Steve tomorrow, whatever the case may be, but it's the position. So if John is the managing director, Steve is the managing director 2 months later, that's okay. It's the positions that ultimately that the that USCIS is looking at and looking at in terms of the business plan to portray and to demonstrate the ability to create the job. As Prema mentioned earlier, it is 10 jobs. However, in the case where you may be buying into an existing business, the requirement is that there be a 40% increase in the number of employees or the net worth of the business. So that's something to keep in mind. All right. So as in the regional center cases, all funds have to be lawfully derived, have to prove that the funds were obtained from lawful sources, and we have to show the path and the full sourcing of all investment funds. Let me step back for 1 second, please. In terms of the additional requirement here, as my colleagues mentioned, you do have to have a business plan. In a regional center, they already have their plan and it's essentially been pre-approved. In a direct case, you have to submit a business plan to USCIS and it has to comply with a case called matter of whole. And that business plan has to be thoroughly prepared and detail literally, the exact plan that the company intends to take in order to create the jobs, should show and corroborating evidence with respect to its ability to do so, including any licensing requirements, permitting, any additional funds that are in the picture other than from EB-5 investors. All of those matters must be detailed. Matter of home must be consulted when these plans are prepared. We recommend using a qualified business plan writer who's familiar with EB-5 to do these plans. All right. Stepping back now, as we discuss business plans. In addition to following the investment, the funds must remain consistently at risk and committed to the NC. Similar to the regional center, this requirement exists. The difference here is the investor here is probably a sole owner or a majority owner, so there's tendency or potential possibility that funds may be withdrawn for some purposes. Have to be careful that the funds are not withdrawn in a manner that's not consistent with the normal operation. So if the investor is, let's say, a sole owner or a 70% owner, and they decide to pull some money to, let's say, put a down payment towards their house from the investment funds, that's a potential problem. At some point down the line, when you go for condition removal and the business bank statements are submitted, it's possible that USCIS may catch on to this and realize that funds were withdrawn outside the normal course of business, and that would be a problem. Funds would potentially not have been sustained. Another aspect to consider when you're doing direct investment is that the funds remain at risk. So, in addition to placing the funds in the company account, you have to make sure that the funds will be potentially utilized and remain at risk. The example I give is if you're going to invest, let's say, $900,000 to open up a hot dog cart, it's very unlikely that you're going to use the full 900,000. Maybe you'll use 25 or 30,000. The remaining funds will stay in the company account. So in that case, the company is probably overcapitalized, and the company funds are probably not at risk because they're not going to be really utilized. So you have to be careful that the funds will be able to actually be utilized and sustained in the business and remaining at risk. All right. So job creation. In the regional center case, you got a prepackaged deal where the regional center will give you all the documents ultimately to show the job creation. In the case of a direct investment, you as the investor working with your lawyer must demonstrate that you've created the jobs. So you need to maintain proper payroll records. Form 941 is pretty much always required. W-2s, I-9 records for all employees, and any state level payroll records are also likely to come into the picture because they usually contain the names of the employees. So these are things you need to take into account. One other thing to just mention before we move on, when do the jobs have to be created? In a regional center, again, you don't have to worry. They take responsibility. In a direct, you're required to create the jobs. The statute says that the job creation has to be completed within 2.5 years of I-526 filing. What that means is potentially you can create the job even 5 years down the line if, let's say, your 526 hasn't been approved. What you have to keep in mind is that the business plan will typically show that the jobs will be created within 2 years. So if you vary too much from the original business plan and decide I can create the jobs within 2.5 years from getting my conditional card, you may run into a problem where the USCIS says you've had a material change. So what I always suggest to clients is try to do the job creation within approximately 2.5 years from the filing of the 526, as opposed to 2.5 years from the approval of the conditional green card. I may have misspoken earlier. The requirement is that the job to be created within 2.5 years from the issuance of the conditional residency. But we recommend you do it sooner, 2.5 years from the 526 filing. All right. So that's basically the direct investment. I'm going to spend 2 minutes on source of funds. although this is probably the most important and difficult component of the 526 and EB-5 filing. Source of funds tracing is very important. Unlike the E2 visas or some other visas that are out there, EB-5 source of funding is very, very stringent and very detailed. Basically, you have to literally document the source of the investment and the path of the funds into the investment enterprise. I usually suggest going back 5 to 7 years. Sometimes you have to go back even further. So an example, a couple uses their family home, which was purchased about 8 years ago, to take out a HELOC, home equity line of credit, and use it for EB-5. USCIS may come back and say, how did you get the down payment to purchase that property in the first place? So here you may need to go back 8 years ago and show that the couple had a job and then they earned X amount of dollars, they had lawful wages, and let's say they invested 50,000 of those funds, of those savings acquired over time to invest and buy their first home. Later on, the property appreciates, and ultimately they are able to secure enough money from the HELOC loan to pull out funds. So again, you need to go back and show where the funds came from. Similarly, if it's a loan or a gift from a family member, and a family member has obtained the funds through a similar situation, you'd have to show how they acquired the funds. How did they acquire their home, which they sold or they borrowed against to provide a gift or a loan to their family member. The analysis is still the same. All right. So the funds can be from gifts or loans, as we mentioned earlier. Current processing, I think Prem already discussed, is between 27 to 48 months. If the investor is already in the US and the I-526 is approved, the priority date is current, you can proceed with the I-485. Think of it similar to an I-140. There's no prior benefit until you reach this stage. If the investor is abroad, you'll do consular processing through NVC and then ultimately through the foreign consulate. So I-829 petition and removal of conditions. So once your green card is approved, you're going to get a conditional, your spouse and minor children under 21 get a conditional green card, which is good for 2 years. Within the 3-month period preceding the second anniversary of that card, you need to file a condition removal application, Form I-829. This applies in the case of an I-8 of a regional center or a direct investment. In the case of a regional center, what you're basically doing is you're reaching out to the regional center saying, hey, I'm coming due for condition removal. Have you created the jobs? Provide me the documentation. They'll usually give you a box of documents or a whole file, a USB drive with documentation showing that they've created the requisite jobs. They know what needs to be submitted. They'll give you their portion. Your attorney will then utilize that to put together the 829 and then submit. If you are a direct investor, it's a little bit more complicated. You want to be involved maybe a year before. Make sure you've almost there in creating the jobs, or you've already created the jobs. You want to sustain that until at least the filing of the 829. In the event that the investment wasn't fully completed by this time, they should be fully completed before the 829 is filed. All the investments should be in by that period. And then if there's additional investments that were done following the 526, then you need to source those funds in detail as well as you would have in the case of the original 526 filing. Here, I wanted to just point out one other point. In the case of a direct investment, one other benefit is that you can do partial investment. You don't have to do all the investments in one shot. In a regional center, typically they want all the funds in one shot, so you have to write a check for the 900 on the day that you make the investment. In a direct case, that's not necessarily required. You can potentially put some of the funds in now and then file the 526 and then tender the rest of the funds at a later stage. Thank you, Sam. Thank you, everyone else.